Hi everyone, I'm Kevin Flores, reporter with the Southlander. I'm here today with Alvaro Huerta, Director of Litigation and Advocacy at the Immigrant Defenders Law Center here in Los Angeles. Earlier this month, the Supreme Court lifted an order by a lower court judge that prohibited federal immigration agents from stopping individuals based solely on their race, language, job, or location. The order had been put in place by a federal judge in California who is hearing a case brought by immigrant advocates who argue that the stops being conducted by immigration enforcement amount to racial profiling and violate the Constitution. After the Supreme Court ruling, the Department of Homeland Security posted on social media that they will continue to, quote, flood the zone in Los Angeles. Alvaro, let me start off by asking you, after hearing, what's been coming out of the federal government since this ruling, what impacts can we expect for the local immigrant communities here in the LA area, and really anyone who might appear to be an immigrant based on the color of their skin or the language they speak?
Well, thanks for having me, Kevin. And I think it's really frightening what we can expect. I won't mince words. I think we're going to see a lot of the roving patrols that we saw before the temporary restraining order was put into place. I think we're going to see a lot of violent actions on behalf of DHS agents, both ICE and CBP, as we saw in countless videos before, again, the TROs were in place, and even since, right? We saw them in what we would argue violating the temporary restraining order even after it was in place. But I think we're going to see some racial profiling, and we're going to see violence against our communities. So it's really disheartening that the Supreme Court is allowing this to happen while the case continues below.
The plaintiffs in the case are three men who were stopped by immigration agents in Pasadena. Can you tell us a little bit about them and what happened in that stop?
Yeah, so our plaintiffs were stopped while they were waiting at a bus stop in Pasadena. Three individuals, all Latino men, who were detained when DHS cars surrounded them, had, identified them by the way they looked, asked them questions about where they were from, and whether they had any papers on them. And they didn't. They said no. And they were taken into custody. And this was an example of kind of the indiscriminate patrols that we were seeing at the time of ICE and CBP agents just driving around looking for people that they thought might fit the profile of someone who's undocumented. And for them, that means someone who's brown, someone who might be waiting at a bus stop or waiting at other specific location looking for work, someone who looks like they're looking for low-wage work, which, if you ask me, that's hard to tell, but they say that that's enough to give them suspicion. And so those three individuals were taken into custody, eventually released through the efforts of our partners on this case, who got them out based on a habeas petition, which is a way of getting folks who are unlawfully detained out of government custody. And then those three individuals really helped us get this case off the ground, which, because of their own situation and in the situation we were seeing of many people caught up in these raids, we were able to amend their case to bring the different claims that we brought, saying that their stop and similar stops were all unlawful and in violation of the Constitution.
And judges in the lower courts were very forceful and unambiguous in the rulings that the way immigration enforcement was defining reasonable suspicion to stop and detain someone in cases like this was unconstitutional. So what was the Supreme Court's interpretation?
So the Supreme Court didn't actually say very much. What we have is a one-paragraph order from the court basically saying that they're going to stay or pause the temporary restraining orders while the case proceeds below at both the district court, and we are also on appeal at the Ninth Circuit. But it doesn't give any rationale. What we do have is Justice Kavanaugh's concurrence, which is not controlling, but it gives us a little insight into what the court is thinking. And according to Justice Kavanaugh, it's okay for DHS agents as long as they believe, because he points out that there is a portion of the population in Los Angeles who is undocumented, because that population may work in certain fields, because that's where they can work, be it day labor or in farms, for example, or because they speak simply because they speak Spanish or English with an accent. That's enough suspicion, according to Justice Kavanaugh, to allow agents to detain someone who potentially fits that profile, and put them into custody. We would argue that's not enough. There are plenty of people who fit any of that description who are lawfully in this country, or who are citizens. So that shouldn't give anyone reasonable suspicion to actually ask people questions on the street, let alone detain them. But that's the extent of the kind of rationale that we got. And that was, again, only in a concurrence, not in the majority's decision, which just simply stayed the TROs pending the litigation.
Yeah, and I want to read a little excerpt here from what Justice Kavanaugh wrote, and kind of the way he describes and envisions the way these immigration-related stops go. This is what he writes. The questioning in those circumstances is typically brief, and those individuals may promptly go free after making clear to the immigration officers that they are U.S. citizens and otherwise legally in the United States. Is this how the scenario has played out in reality, and was this the case for your plaintiffs?
Yeah, that is absolutely not what we've seen, and what I'm sure your viewers and readers saw with their own eyes in the many videos that were out there, right? What we saw was violent actions by agents of the Department of Homeland Security, ICE, CBP, bringing people to the ground, accosting them, not letting them get a word in. Some of them were trying to say that they had an ID, that they had a passport, that they had some proof, and not being allowed to actually provide that before they were detained, before they were taken into custody. We know that citizens and lawful residents were taken into custody and held there in different facilities for days on end sometimes. And often when they were held, it was hard to locate them because we didn't know who was taken in. Family members would call our organizations to see, because they thought maybe one of their family members were taken in by these roving patrols because they had gone missing. And sometimes it took us a day or two to locate that person in the system. So we know that it's not this polite interaction. We know that people feel coerced into they can't remain silent, which is what we advise that people do, but they feel like they can't because they're not even given an opportunity to explain their situation. Instead, they're rounded up, tossed into a van, and taken into a detention facility, and maybe disappeared for a few days.
And like at the center of this case is this, how reasonable suspicion is defined. Is there a different standard between sort of, local police, sheriffs, and the way they define that versus the way immigration agents have typically defined that?
There shouldn't be. There really isn't, right? The Fourth Amendment protects all people from unreasonable searches and seizures. And that means that without reasonable suspicion to believe that someone is committing a crime or is about to commit a crime, that person cannot be subject to a search or seizure. And the agent or police officer needs to be able to articulate that, needs to be able to say, what reasons are they using to believe that someone has committed a crime or is about to commit a crime or is about to flee the scene? If they can't articulate that, then they don't have reasonable suspicion. And it has to be individualized. Again, they can't say, oh, we know that a group of people who hang out in this area commit crimes. If you're among that group of people, that doesn't mean that they don't have to prove that you committed a crime or about to commit a crime. It has to be individualized. And so that's why the Supreme Court's decision, or non-decision in this case, is really disappointing, because all we've been asking for in this case is for all of these agents to follow the Constitution, which is very clear that they must have reasonable suspicion and they must be able to articulate what that reasonable suspicion is.
And one of the plaintiffs in this case is a U.S. citizen, and there's a video of this stop where he's being roughed up by immigration agents, and he's yelling, "I'm an American." How widespread has this been that people with legal status are getting caught up in this President Trump's immigration dragnet?
It's been happening quite a bit, and we've seen a number of videos. The individual here, our plaintiff Brian, who a lot of people saw that video where he was, accosted. He was trying to say he was a citizen. The agents then responded, "What hospital were you born in?" And he didn't know. He didn't know the answer right away. I'm sure there are lots of people out there who might not know exactly what hospital they were born in or might have forgotten it, especially if you're in a situation where you're being asked by armed agents, masked agents, who don't even necessarily identify themselves. You're being asked some question like that where you don't have time to even think of the answer. Eventually, he was released, but they never. He gave them his ID to prove that he was in the country lawfully, that he was a citizen. He never got that ID back, and he went through that situation where he was held, accosted violently, eventually released. But that's an indignity for anyone to have to go through. That is just wrong. And our Constitution says it's wrong. That's why we have these protections. Unfortunately, we have seen it in other cases as well, and I think we're going to see it. I think the really disheartening thing is that we're going to see a lot of folks with lawful status, a lot of citizens go through this same situation, not being able to immediately prove that they're citizens. I walk around with an ID. That doesn't necessarily prove that I'm a citizen. I don't walk around with my passport or my birth certificate, and I don't plan to. But what this administration is saying is basically you have to, in order to not be accosted. And frankly, you might still be accosted if you're brown or don't speak English without an accent. So it's really, it's unfortunate. This is going to be happening a lot more. And I don't want to say that it's only unfortunate because it's happening to citizens or lawful residents. This shouldn't be happening to people who are undocumented either. Like, they should not have to worry that just by walking outside the door that they might be pushed to the ground and taken into custody and that their family won't see them for a few days. No one should have to live through that.
What rights do people have, whether they're undocumented or documented, during these types of stops, and what should they do if they're approached by an immigration enforcement agent?
So it's really important that people do understand their rights. That's the first thing. I think, unfortunately, too many people don't know what they would do in this situation, and it can be tough, right? You're in a high-pressure situation. So first of all, it's important to stay as calm as possible, not run away. You can talk to the agent, and you can ask them, am I being arrested? Am I being detained? If they say no, you can walk away, calmly walk away. If they do say you're being arrested, then you can ask why. Under what reason are they arresting you? You have a right to know why you're being arrested. And if you're being detained without them articulating why you're being detained, you should remain silent. Otherwise, if they're not letting you go, you should basically ask to speak to a lawyer and then refuse to answer any other questions. If you are taken into custody, you can continue to refuse to answer any other questions without a lawyer present or having talked to a lawyer before. And you can make sure that you do not, absolutely under no circumstances, sign anything that you don't understand. Anything that's not presented to you in a language that you can't read, or that's presented to you without an explanation of what that is, you shouldn't sign anything, really, unless you've talked to a lawyer. Unfortunately, a lot of people feel coerced into signing away their rights before talking to an attorney. And we have heard of people who didn't realize that they were signing basically their deportation order, their removal, giving agents permission to basically take away their right to go before a judge, for example, to explain their situation. But in every single case, no matter what your status in the country, you have a right to remain silent, you have a right to ask for a lawyer, and you have a right not to really answer questions or sign anything until you do.
And I've seen on some videos people recording some of these stops and these detentions asking for a warrant. Do federal immigration enforcement need a warrant for these stops or to detain someone?
Well, so they don't need a warrant if they're just stopping you and asking you questions. If they're asking you questions, they actually have a right to ask questions that then get a voluntary answer back. That's why we're saying you don't have to volunteer an answer. They can ask you questions. You don't have to volunteer an answer. They can do those types of stops without a specific warrant. Agents do need a warrant, though, if they're going into your home or if they're going into a place of work or a location that's typically private. And so they will have to show a warrant in order to enter any of those places. So if you're at your home, you can ask to see a warrant and ask to see it from the other side of the door. You should not come outside. You can ask from a window or a door to see a warrant. If they have one, they do have a right to come in. But that warrant has to either specifically say the name of the person they're looking for or the places that they're allowed to search. So if it doesn't, you should check for those things. And if it doesn't have those things, they might still search, but you should say that you don't consent to the search. All that can help you down the line later in court when you and an attorney are trying to show that the search was unlawful. If it's at a place of work, and this is why we really encourage employers to set where things are private and which areas are public. Public places might be a parking lot or a waiting room at a hospital, for example, or at a mechanic shop, a waiting space while you're waiting for your car. Those might be considered public, but private areas are any office spaces, anything where only staff are allowed. Those are private spaces. In order to enter those, Immigration and Customs Enforcement would have to have a warrant as well. And would have to show that warrant. So we do encourage people to make it very clear what's public spaces, what are private spaces.
So you mentioned that people can file a lawsuit down the road if they feel they were stopped or detained unconstitutionally. Have we seen this happen already? Have there been, and what have been the outcomes of people who might have filed lawsuits like this against the government?
Yeah, so if you suffer some violation of your rights on behalf of the government, you are entitled to sue. I haven't been involved in many of those cases lately, although I'm sure there are plenty of those out there that are being brought by individuals caught up in some of these raids. We've been focused on this larger kind of class action that we're trying to get it to be a class action to attempt to stop the raids altogether. But it is true that you can bring litigation and showing that the government violated your rights. And oftentimes, if you're able to win that litigation, you might be entitled to damages or money compensation for something that happened to you. And we need to raise those types of lawsuits against the government if we feel that our rights have been violated. I think it's important to hold our government accountable, and that's one way of doing it, is to sue them when they violate our civil rights.
Let me take a step back here for a minute. The U.S. has a long history of xenophobic, anti-immigration policies at the local, state, and federal levels from both Democratic and Republican lawmakers. Can you talk a little bit about that historical context from a legal sense?
I mean, I think there are even lawsuits out there claiming that our immigration system is fundamentally racially motivated, right? Before the maybe last 25 years, we had very different laws on the books. Immigration was handled very differently in this country. It's been since 9/11 that we really have seen this crackdown using our immigration system and these ideas of national security to really bring the hammer down on people of color in this country, to exclude people that we don't think are American enough, quote unquote. And those often are people of color, right? Whether it was in 9/11 when we had Muslim registry laws put into place, or as we saw in the early 2010s when a series of different states tried to pass anti-immigrant laws, the kind of equivalent that we're seeing now of these show me your papers laws that were happening across the country and got started in Arizona and moved on to Alabama, Utah, South Carolina. We've seen just this incredible use of our immigration laws to target people of color. And historically, unfortunately, it's been historically true that the immigration laws have been used to exclude rather than include people who all they want to do is look for better opportunities in our country. So there's cases that have been trying to prove that a lot of the laws on the books are racially motivated. One example are the criminal laws that make unlawful entry or unlawful re-entry into the country felony convictions. There's now legislative history that people have pointed out that shows that those laws put on the books were motivated in response to a sudden increase at the time of immigration from Latin American countries, and that there were Congress members who were motivated by the sense that we were being quote unquote overwhelmed, or, you know, to use the logic of today, invaded by other people from Latin American countries, and therefore we need to be tougher. So there's unfortunately too many examples in our immigration laws that show the racial motivations behind them. And that said, there's also really good examples of how, when you look back at the Immigration and Nationality Act and the civil rights laws that were passed in the 60s and even late 50s, that there was some good motivation too, right? We started getting rid of things, the quotas, for example, that had been previously put in place that restricted immigration from certain countries altogether before, or put quotas on the number of people who could be here from those countries. So we've made some great advancements over the history of our nation, but as has been proven in recent years, we have a very long way to go.
So where does this legal battle go from here? I believe it's still playing out in the lower courts. The Supreme Court ruling isn't the end of it.
That's right. The Supreme Court, that this particular ruling is not the end. We're still going to be, the case is proceeding in federal district court. We have another hearing in the case later this month on September 24th. And then we're still waiting to hear from the Ninth Circuit on the government's appeal of the temporary restraining order on when they appealed a few months ago. So it's proceeding on a lot of different tracks. We'll get a chance to provide even more evidence to the district court of all the different violations, constitutional violations that are occurring during these raids. And we're hopeful that the court will agree with us that we need to put a preliminary injunction in place to pause these raids and warrantless detention and warrantless raids again. And that means that it's also not the end of the road. We'll probably end up back before the Supreme Court sometime in the future, because no matter what ends up happening in the case, either side is likely to appeal whatever ruling comes out to the Ninth Circuit Court of Appeals, and then likely up to the Supreme Court.
Has it been helpful in these cases to have video recordings of these stops? Because we interviewed somebody a couple weeks ago who was recording ICE activity. It wasn't even a stop, just ICE activity, and you know, they were a U.S. citizen, but they were arrested and detained. It seems like for that reason, and it seems like these federal agents are very fearful of people recording their activity. So, has this been helpful in a legal sense?
It's been incredibly helpful in a legal sense. We've been using those videos and recordings and then following up with those people who recorded to get their account of what happened. And it's incredibly useful to show to the court exactly what is happening on the ground, right? To show that there was no reasonable suspicion, there were no other factors that were being taken into consideration, that they were chasing down people, that they were taking in bystanders. It's incredibly important to get those videos recorded and to get those submitted to our legal team, because we will use that as evidence. And beyond their use in the legal case, they're really important to really show the public what is happening, right? You mentioned what Justice Kavanaugh, his description of what is happening on the ground doesn't coincide with what we're seeing in those videos. And I think when people see what is actually happening and the actions that these agents are taking, masked, unidentified agents are taking on the ground, they're starting to realize This isn't about the Trump administration, what they claim, that they're targeting specific people with criminal backgrounds. Again, not that those people don't have rights either, but it's not what this administration is saying. They're targeting paleteros out on the street. They're targeting people selling hot dogs. They're targeting people who are just trying to make an honest living out in the streets, and others, right? Other bystanders, citizens, and those with lawful status. So it's really incredibly important that people see what is happening, and we do encourage people to continue to record, continue to bear witness, do so in a way that protects themselves, right? You can do it from a distance. You can do it as long as you're not interfering with the investigations. But you can also provide information of the people who are being arrested. You can tell them to remain silent. You can tell them to ask for a lawyer. You can tell them not to sign any documents. All of that is really important because, we have, in a sense, been abandoned by the Supreme Court for now. And so it is really going to take community members looking out for each other and helping each other out during this difficult time.